On the proffer, the law, this is a unique situation in a proffer punitive damages. I'm sure Your Honor is aware, the proffer statute was put in place because of negligent situations where people would throw punitive damages in a negligent situation.
May I request that you understand that as a student of the law for 32 years, that you saved the history of the statute and how it came to be. Remember, I do this on a daily basis, and this is not the first time that I have heard any kind of argument on a request to the court to allow punitive damages.
Okay. If I may, and I won't give you the history, but I do want to make one point that makes this unique.
Okay.
In that this is an intentional tort case.
Okay. Yeah, and defamation is an intentional tort.
And as an intentional tort case, it is different than your typical negligence case.
Completely.
Okay.
Completely.
All we have to do in a intentional tort defamation case is you look at the four corners of the complaint. It's treated according to the Fifth District Court of Appeals like a motion to dismiss. And we simply look at and say, is there sufficient allegations here to support that this is an intentional tort? Once you're there, punitive damages automatically come in that tort, as opposed to negligence. It's because it's a willful intentional tort.
Right, that's one of the elements.
And consequently, what I would...
So in other words, what you're saying is your threshold is similar to meet than if we were dealing with a negligent tort.
Yes, sir. You got it. In other words, I don't have to come in and say, this is really, really bad negligence. I just got to say, all I have to do is say it's an intentional tort. We get it automatically so long as we said the magic words for the intentional tort.
So long as you provide a proffer.
Right. And let me get to that.
That's what the law requires.
And we have presented in our proffer to Your Honor, we did it in writing. And let me highlight some of this to you, and then if there are any specific questions, I can go beyond that. There are a whole bunch of facts proffer, but I'd like to get down to the key ones because we're short on time. On the question of the intentional tort of defamation, the facts are that our client didn't do it, number one. They don't even claim she did. She's clearly innocent, number one. That's the starting point of kidnapping or killing Caylee Anthony. Number two, Casey Anthony identified Zenaida Gonzalez as the person that did it. They argue, well, it's not you. So let me go right to that point. The question of it wasn't this Zenaida Gonzalez is twofold taken care of. The first step is through the Sawgrass. She said she was the Zenaida Gonzalez that kidnapped her child and ultimately would have killed her child was at Sawgrass Apartments. The evidence that we have proffered, Your Honor, in our written proffer shows that our client went to Sawgrass Apartments within a day or two of the time the child went missing and filled out this, or she didn't actually fill it out. A form was filled out because she was thinking of renting them, and her name appeared on the form. Casey Anthony has friends at Sawgrass Apartments. There has never been any other Zenaida Gonzalez in the history of the world identified with Sawgrass Apartments at all. Casey Anthony sent the police to Sawgrass for the Zenaida Gonzalez. The Zenaida Gonzalez, with the only contact was our client, they then found our client and talked to our client. Our client said, I don't know this lady. Never heard of her, never babysat for her, don't know what in the world you're talking about. At that point, that was a defamation to her. They can argue, oh, it wasn't you. Their argument is we described somebody different.
That would be a defense.
That's a defense. It doesn't end the proffer. Because, of course, at this point, we're just trying to plead it. We got other hurdles we have to go through. This is just the preliminary safeguard where you just simply plead it. That's a defense. It doesn't get in the way of our proffer, number one. Number two, it doesn't stop there. The identification specifically, and they will say, well, she described somebody with a different description. I can get into all that, but I don't think it matters. First of all, she's never seen her client, so she couldn't describe.
I think by the filing of the depositions, I think there's sufficient information on the record where that might not survive. that claim might not survive on the opposing side,
Correct.
that at least may, I have read the document.
If you've read it, then I won't bog down in all
I think
the
you can
details.
get it. I think you get that I've read from the question.
I'm getting that. Yeah, I'm glad. It saves me a lot of time of pointing every
That's the
single
whole
answer.
idea. That's the whole idea for preparation.
And let me give you the second piece of it. And that is, whatever question they can raise, which I think Your Honor has recognized wouldn't prohibit the amendment anyhow, but just to deal with it so I don't have to hear a whole lot more about it.
Well,
This-
my job is to hear it.
Okay.
And if that's what I have
My
to do,
piece of
I
mind,
will.
I'm going to say the second piece of it. Because it's the nail
I
in the
have to
coffin,
get
Your
my
Honor.
exercise other than by jumping to conclusions.
All right. Well, then let me give you some proper facts so we don't have to jump to conclusions. The
Others
first-
can jump to conclusions, but I cannot.
Agree. In addition, once the police went out and found the only Zenaida Gonzalez that had any dealings with Sawgrass, and she said, it is me. And by now, the circumstances are that Casey Anthony's been caught in a bunch of lies. She's told him I was working at Universal. She's told him, admitted now she didn't really live with Sawgrass. She admits the previous apartment that Zenaida Gonzalez lived at, she made that up too. So obviously the police are now saying, I got a lady here we can't believe. And they've now met Zenaida Gonzalez, the only one with the connections to Sawgrass, and said, I don't know the lady. And apparently it was believable to the police. So they took a picture back to Casey Anthony and showed her the photograph of our class.
And that's what's in the depositions.
That's in the deposition.
Let me ask you, how is it that you would want the court order to read?
I would want
I think you're basically arguing facts that I can take judicial notice
Sure.
because, as I indicated, they're in the deposition. You know them, opposing counsel knows them, the world knows them. How do you want
all I want the order to read is that the court finds that accepts the proffer and grants leave to amend, to plead, to file the amendment, including punitive damages.
counsel, why should I not rule that way?
Judge, I don't think you should rule that way really for a couple of reasons. Number one, firstly, if the adequate research was done before the rush to file the complaint was done, they would have initially have pled a punitive damage claim.
Really?
Really? Because to this point, Judge, Detective Melich, the individual that Mr. Mitnick was alluding to, who showed the photo of a Zenaida Gonzalez to my client, has yet to be deposed. In his statement, Detective Melich indicates, I showed the photo. Miss Anthony indicated, I didn't recognize the photo. Mr. Mitnick then in the previous pleading said, Judge, well, that will be vitiated by the argument and the testimony of Lee Anthony, Cindy, and George Anthony, who will all contradict that statement.
Why is that not a question of fact that may have to be decided at a trial?
It may have to be decided at trial, but what I'm saying to the court is that that is the foundation, if you will, that Mr. Mitnick is attempting to use as a jumping off point. And in this particular instance, he was wrong on all three occasions. Lee, George, and Cindy all indicated, I had no idea who that lady is. None. The lady was sitting 3 feet away from her at a deposition. Has no idea. No idea. But interestingly, Detective Nelson...
You've got a good point. But your point basically is as to time and place deals with when these individuals were making the statement as a result of a deposition. And I think what's at issue here, which is the alleged defamation, it's not about what happened at the deposition, but it's what happened before. And I think that at this point in the litigation, I cannot take one statement over the other. If there are two statements that are opposite, it becomes a question of fact for the jury. And that would prohibit me from, well, actually it would require that I grant the motion. Give me a second observation.
The second observation
This one doesn't carry weight.
Okay, that Mr. Mitnick just alluded to this form at the Sawgrass apartment that Ms. Gonzalez filled out. Interestingly, Judge, in the discovery that was submitted in this case from the state attorney's office, The form initially includes the name of Zenaida Gonzalez, Gonzale, no Z. I find it strange, Judge, that a woman would misspell her own name. It doesn't indicate Zenaida Fernandez Gonzalez. It is misspelled, indicating again to me